Hi, welcome to our training on landlord tenant law. My name is Heather Hulit. I'm the legal director here at Christian Legal Clinics. And my goal of this training is that you are comfortable with talking to a client about their landlord tenant problem. Not that you're going to be an expert and take a case, but that you'll know which category of problem they have and be able to give them some basic advice. The good thing about this area of law is there's only so many categories of problems. So 98% of the problems you'll see will fall into these categories that we'll talk about today. Everything we talk about today is law that applies to all of Pennsylvania. There will be little parts that only apply to Philadelphia, and I will point those out as we get to them. So let's get started. Okay, so like I said, my name is Heather Hulit. I'm the legal director at Christian Legal Clinics. My experience with landlord tenant law began, let's start at the beginning here, began at Community Legal Services, where I was for several years during and a little bit after law school. And then since then, I've volunteered in this, taking cases from Christian Legal Clinics. So I've stayed current on what's going on. So the common landlord tenant problems that you're going to see 98% of the time is that a tenant has repair needs and the landlord is unresponsive. That the tenant's behind in rent and the landlord is sending threats of eviction. The tenant has eviction court. That the tenant has moved and has asked for their security deposit and the landlord has not sent it, or that they have been illegally locked out. So a concept that I think folks outside of landlord tenant sometimes fail to appreciate is that you don't need to have a written lease to be a tenant. An oral lease looks like this. I have a house. I talk to my friend. I say, hey, you can live there for $500 a month. Pay the utilities, and they say, okay, and they pay me $500 and they move in. They are now a tenant, I'm a landlord. All the landlord tenant law applies to our contract, even though it's an oral contract. So this includes written leases. This includes written leases that have ended. The date was April 14th, 2021, but it automatically renews month to month. So even if that lease date has ended, the person's still there paying rent, they continue to be a tenant. Month-to-month leases, oral leases, leases between family members. Anytime there is an exchange of money and you live in a property owned by the person you paid money to, you are now in a landlord-tenant contract. It's extremely important for tenants to be able to prove they are a tenant. This applies, we see this problem a lot with like rooming houses. So these are usually not legal rooming houses, usually not zoned as a rooming house. Usually the owner is not licensed to operate a rooming house, but nonetheless, they will collect money from various people to rent rooms. And they will accept cash because they would like it to not be on the record, because they would like to not have to report it as income. And so people will pay them cash. And then when the landlord wants to get rid of you, you have no proof of being a tenant. So they just kind of put your things outside. So the biggest thing tenants can do in those situations to protect themselves is make sure they can prove they've paid money to the owner. So anytime you're talking to a landlord and they say cash only, that is huge, massive red flag. Always do money orders at minimum so you have some proof of payment and who you're paying it to. Without these proofs, tenants really are vulnerable to being illegally locked out. So let's talk about repair issues first. The biggest thing is giving your landlord notice in writing. So that can be a text, that can be an email, that can be a letter. It used to always be letters, but now it's mostly text. In some form that you can show the picture to someone. So if you're texting it, you want to take a screenshot of that text and save that to your computer, email it to yourself so that you have proof that you gave notice on such and such date of these different issues. In response, the landlord can either do the repairs in a totally satisfactory way. They can kind of slop some spackle on it and do it in an unsatisfactory way or send a guy to patch it up. Or they can just ignore you completely, tell you it's your problem, they're not coming, or say nothing at all. So if there's no response, if you're in Philadelphia, you can call License and Inspection at 311 to request an inspection. If you are anywhere in Pennsylvania, your next move would be to write another letter to your landlord, again, email, letter, text, stating that you're going to repair and deduct your rent, repair and deduct from your rent, or that you're going to withhold or partially withhold rent. So for instance, at this moment, my neighbors do not have use of their water. There's some under the ground plumbing problem. They haven't had water about a week. So they will be able to say to their landlord, listen, from this period of time, from now that I have no water until it's fixed, we're gonna deduct those days of rent because we don't have full use of our house. We can't cook, we can't clean, we can't take showers, right? Or if it's like a heat repair, you might say, I'm going to withhold my rent until it's fixed. Something on those big issues like water and heat. Repair and deduct are remedies. Both of these are remedies found in the Landlord Tenant Act, and we'll talk in a minute about when to use which remedy. There's a sample letter you'll be able to give tenants, which I can show you really briefly. I thought I could do it really briefly. So this letter, super simple. Dear Mr. Landlord, I rent a unit from you at the address for X amount a month. As you know, I had these repair issues. I first told you about these issues on this date. And again, on this date, you list all the dates you've said it. If these are not addressed by the next rent due date, I may repair and deduct, or I might withhold. Please contact me at this number to address. So it doesn't have to be complicated. This is a letter that you can help our clients write, because sometimes they're just not confident of how to frame these things. And often they're mad. And so it's easier for you outside of the situation to write a letter that they can use as an exhibit if they're ever in court. A good rule in terms of which strategy to use, repair and deduct versus rent withholding, is to be only as aggressive as you need to be to get the thing done. You want to gradually turn that dial up as needed. So repair and deduct is far less aggressive than rent withholding. It's appropriate for smaller repairs that cost less than 1 month's rent, a door lock, a non-working outlet, a small plumbing issue. Rent withholding is more appropriate for big repairs. Like I said, the water being unusable, that's pretty big. A sewage pipe leak, your sewage in your basement, broken heater, a roof leak, something that takes more than a month's rent to repair. In terms of how many days you give a landlord before taking one of these actions, again, it kind of depends on the nature of the repair. If there's no heat in the middle of winter, 5 days is appropriate. This isn't fixed in 5 days, I'm going to withhold my rent. For other less dangerous repairs, something closer to 20 or 30 days is more appropriate. All right, let's say this probably happens the most, is that a landlord comes and slops some things on a wall, and you look at it's going to leak again. So tenants will come in like mad about this. So the roof's leaking into the living room, landlord sends a guy who patches it up. The guy tells you the roof's 20 years old, it needs to be replaced. Repair guys will talk to the tenants. The tenants are mad. It's not fixed correctly, come back. Bathroom sink needs to be recaulked so it leaks, causes the kitchen ceiling to cave in, landlord comes in and patches it. Tenant knows it's gonna fall out and happen again. This is probably the diciest area. The landlord as the owner can send in whoever he or she wants to do the repair. The tenant has no say on whether they're licensed, experienced, or qualified to make that repair. So the question becomes, is it done enough that I should pay rent? So if you're in Philadelphia, wait for L&I to inspect. If they mark the violation satisfied, which they will, if the leak has stopped, they're gonna mark it satisfied, then you should pay your rent. If you are no longer affected by that repair issue anymore, again, it stopped leaking, resume paying rent. And then when it happens again, you start the wheel over. You can always communicate in writing to your landlord your concerns about how repair was done in the event those issues arise a short time later. So I've said, hey, this thing is leaking. You've come out, you spackled it, but you didn't fix the leak. I'm gonna write a letter being like, hey, thanks for spackling it. I'm concerned because the leak is still ongoing. I can hear it drip. And then when it happens again, there's this nice chain of documentation when they take me to court for withholding my rent. Retaliation, speaking of court. So retaliation is prohibited by the Fair Housing Ordinance. This applies to Philadelphia only. If the landlord gives you an eviction notice verbally or in writing within a year of you informing them about the repair needs, the landlord has the burden of proof to prove the eviction is not retaliatory. So even if you make your request for repairs, the landlord comes right out and fixes it. But within a year of that, they send you an eviction notice. You go to Fair Housing Commission to file a complaint. This is the address down here in the PowerPoint. Again, this is just Philadelphia, but that moves the burden of proof onto the landlord to prove that this is not retaliatory. They have some other basis to evict you, to end your lease. Even if you're in a year lease and the year is up and they give you an eviction notice, they still have the burden to show, well, why aren't you going to continue renting to this person? They have the burden to prove that it's not retaliation. So this is somewhat repetitive what I just said. If the landlord gives you a notice verbally or in writing within a year of you informing them about the repair needs, then the landlord is the one that has to prove that it's not retaliatory. And if you go to Fair Housing Commission to file your complaint, they can't then go to municipal court to file a complaint. You have jurisdiction in fair housing now. So it's a nice way of preventing them from running over to municipal court and filing an eviction complaint. All right, next category of problems is behind in rent, job change, job loss, roommate moved out, girlfriend moved out, loss of the income that was being used to pay the rent. So when the tenant begins falling behind on rent, the best thing that you can do is get in front of it instead of avoiding the landlord. As people, we can often kind of put our head in the sand, but it's better to go ahead and confront it and then try to work out a leaving early situation or payment plan or something versus just waiting for the bomb to drop. So a temporary financial issue, I lost my job, I started a new one in 3 weeks. Try to make a payment plan before the landlord sends you an eviction notice, before there's a court date. Make sure it's all in writing. A longer term financial issue, try to make an agreement with your landlord about ending your lease, perhaps waiving return of your security. Maybe you paid security last month's rent. So making an agreement, I'll waive return of those if you give me till this date to move out. Again, make sure it's all in writing. If you can have a conversation with your landlord, if you've built some rapport with a landlord, that's going to serve you well when there is an issue. So third issue, tenant comes in and has a court date. So this is all applicable to Pennsylvania. The form will be different, but the process is the same. Again, this is controlled by the Landlord Tenant Act. The first thing that happens is a written notice to vacate, then a complaint, then a court hearing, and then 11 days after that, a writ of possession, and 11 days after the writ of possession, a writ alias. Some weeks after that, an eviction officer serves it to you, and that is the date of eviction. So the first thing that will happen with a notice to vacate, tenants will sometimes come in with a notice to vacate that says you have to leave in 30 days or 10 days, and they're freaking out. Tenants do not need to move by the date provided in the letter. Tenants will often think that somebody can lock them out at the end of that time period. They can't. So it's a big thing to assure tenants. Landlords can't lock you out without going to court. However, tenants should call the landlord to try to work out a date. That's when they should start negotiating if they haven't already. Some landlords make a habit of giving the notice to vacate the same day they file, just to check the box. Landlord tenant complaint, that's the next step. Tenants do need to go to court. The worst thing you can do is not go to court, because the landlord can stand in front of the judge and provide bad information, right? They might complain if we're in April and their complaint is for January, February, and March, but you paid April. They're in front of the judge. They can say, and April, we didn't pay April, and they can add that in because they check a box for ongoing rent. You definitely want to go to court. Tenants will have the option at court of signing an agreement or going before a judge. Unless a tenant is coached on how to negotiate an agreement, they should go before a judge. They go in front of a judge and lose, they can appeal. There's still some options they have. If they sign an agreement for a payment plan they can't keep, which they'll often feel pressure to do, they are stuck with that agreement. And what ends up happening is they leave court feeling like they're safe, but they're just as unsafe as if they went from the judge and lost, or if they didn't show up at all. They can still be evicted just as fast, because landlord attorneys will arrange that first due date so that if you miss it, they can still file the writ of possession and file the writ alias at the same timeline as if you lost in front of the judge. So the appeal process is favorable to tenants so long as they can keep up with the formal requirements of escrowing rent and responding to the complaint. The Court of Common Pleas, applicable to all Pennsylvania, the Court of Common Pleas is a formal place to operate, right? It's not just complaint is filed, you get a court date. Complaint is filed, you got to file an answer by a certain amount of days, and if you don't, you get a default. So tenants are going to need some coaching. But they have the ability to do this. And the reason the appeal process is favorable to tenants is because it's de novo review. They're not looking at what was discussed on the lower court. A new complaint has to be filed. So that de novo review is helpful. And that if they can pay their rent escrow with the court, they pay their rent literally to the court, then the landlord can't evict them while the appeal is pending. So if the appeal was a 4-month process from filing to court date, during those 4 months, the tenant's protected. It gives them major bargaining power, even if they do owe back rent. On the other hand, like I said, judgments by agreements, you're stuck with it. They're unappealable. The third issue, maybe this is the fourth issue. The fourth issue that you're going to see a decent amount of is failure by landlord to return a security deposit. So the Pennsylvania security statutes require return of security deposits and any prepaid, any accrued interest within 30 days of a tenant moving out. So upon moving out, tenants should clean the unit, take photos of each room and inside the fridge, inside the, stop at the stovetop, so they can prove they left no damages or mess. They should send a letter to the landlord demanding return of security and providing new address. Again, email, letter, or text. Just make sure you can keep that text. You save it to yourself. Save it and email it to yourself. If no return of security deposit within 30 days of the letter, you can sue for double damages. A lot of tenants don't know that, and that's powerful motivation as a landlord to be timely in returning it. Really, what landlords and I think a lot of people will do is if it's an easy way to keep money, they'll keep it. So if you make it troublesome for them to keep your money, they'll return it. If you write a letter and then you sue them, they don't want that lien on their property. And the good thing about suing landlords is you know that they have a property so that there is a lien. There will be a lien against that property. Homeowners stand to lose more than non-homeowners when they get taken to court because they don't want those liens on their property. So I've had a situation, this last bullet, will I get paid? I've had a situation where I helped two friends of mine get their security deposit. They write the letter, file the complaint, get the double damage judgment, and then it sat for like 2 years. And then the landlord sold the property and they got a check in the mail. They have to clean up those liens before they can sell the property. So it is worth doing, even though it won't result in an immediate check. The judge is not handing you a check, but that judgment is powerful. At some point, that title will change and you'll get a check. All right, illegal lockouts. This is the last section of problems, category of problems that you're going to see. They're also referred to as self-help evictions. So the law applies across Pennsylvania in terms of this being illegal. However, specifically in Philadelphia, there's a lot of illegal landlord tenant situations, right? Like we mentioned a person with a house or single family home renting out rooms. There's always going to be people renting those rooms. There's a lot of desperate people living in subpar housing from owners who shouldn't be renting. And this is because it's a city where half its population rents. And I think just as many spend a third of that population. I think half of them spend over 50% of their income just paying rent. So finding affordable housing is a real problem here. And so you'll see situations. You'll see people renting out rooms. You'll see divided up family homes cut up into separate units without perimeter zoning. You'll see a random person take over an abandoned home without obtaining title and renting it out as if he owns it. You see this in areas where there's a lot of abandoned buildings, home that was, the person died and didn't have a will and nobody retitled it and they live in another state. Someone conveniently just starts pretending it's theirs and renting it out, making some money. Landlords who are renting out properties in these type of scenarios are not willing or able to obtain the business license and the renter's license that you need to file for eviction legally. Sometimes even when the landlord is legally renting a unit to the tenant, they will still neglect to go through the court process. So that's kind of the background on why it occurs, but what do you do? So an illegal lockout can look like changed locks. I've had a really nasty landlord remove the door. I've had landlords go into the basement and shut off utilities. And some of these stories get crazy over the years that I've heard, like really crazy, violent, scary stories. Tenants' rights in the event that they come home and their electric's off, their water's off, their gas is off, their locks are changed, their door's gone. The tenant should call the police to make a report and then re-enter the property, even if it's by force. The police are not going to assist, but they've taken their report and now you are free to get new locks on the door. You're free to break in and then get new locks. You're free to break a window and then buy a new window. You might have to break locks and go into the basement. The police are allowed to, it's civil, but the police come out and take the, so it's a civil violation, but that Philadelphia code is what directs the police on what to do in an illegal lockout situation. Whatever you spend on re-entering the property can be deducted from your rent. So keep all of your receipts. I'm helping a woman now where she's had to spend some money getting new locks, and those are receipts that she is now using to countersue the landlord in his eviction complaint. And that's it. Like I said, this isn't going to teach you everything there is under the sun, but most of the tenants you see will have one of these 5 problems, and now you know a little bit about what to tell them. So thank you so much for volunteering with us, and I hope that this gives you some level of comfort about seeing these tenants. Take care.